Good morning or afternoon, depending upon when you're listening to this lecture. Okay, so you might ask why we have laws. Do you suppose that if we just left well enough alone, we could trust people to behave and not do bad stuff? I don't know. It's interesting to think about what society without laws would be like today. Have we become less barbaric? Is humankind evolved at all? Let's begin to answer these questions with the history of law. The first laws were primarily used to deal with the institutions of marriage, property, and government. These laws were mainly tribal laws and had very practical purposes. These were not exactly formal law as we think about it today, but rather customs that had the force of law. Societies at that time, and we're talking about more than 5,000 years ago, were mostly based on consensus. Uh, there was not much diversity in ancient tribes. Crimes of violence were personal matters to be handled by the victim or the victim's family. The offender had to make things right. If a person killed a man's child, one of the offender's children would be killed. There were no governments that interfered in what we considered family or tribal matters. Formal written law emerged about 3000 BCE when city-states were beginning to form. City-states were necessary as trade with neighboring communities began to be more prevalent. The first written laws were found on clay tablets among the ruins of Ur, a city-state. King Urgengia of Lagash, I don't think I pronounced that right, was attempting to free poor people from abuse primarily by the priests, which is kind of interesting. At that time, a priest could go into a widow's garden and take her fruits and vegetables if she didn't pay her taxes to the church. The church was also charging exorbitant burial fees. Furthermore, when they made sacrifices, this is when the priests made sacrifices to the god, the priests kept the sacrifice, the goats or cows, for themselves. The king did not think this was fair, so he made laws so that the priests could not take advantage of the poor. At that time, kings were thought to have a direct link to the gods, so the people accepted the laws as divinely inspired. As trade grew, city-states formed into the Empire of Samaria, which is roughly what we now call Iraq. Since then, like now, empires were at war with each other. As a product of the war between the Sumerians and the Akkadians, Babylonia was formed, and its most famous king was Hammurabi. Hammurabi prayed to the sun god, Shamash, for guidance, and he was given 285 laws, which became the Code of Hammurabi. Each law had a specific penalty. These laws were covered things like personal property, real estate, trade and business, family issues, injuries, and labor. The whole idea was to prevent the strong from oppressing the weak. The punishments varied according to class standing. This was the eye for an eye, lex talionis school of ruling, and was very barbaric. If you were a slave, you might be killed, whereas if you were a free man, you might just lose a limb. So fast forward about 500 years to around 1100 BCE, and we have the more familiar law of Moses, or the Mosaic Code of the Israelites. According to tradition, God entered into a contract with the tribes of Israel in which they agreed to obey his 613 laws, which included the Ten Commandments. And in return, they would have God's special care and protection. The Mosaic Code was the foundation of Judeo-Christian moral teachings, but perhaps even more importantly, it began the disconnection of the king and divinity. Fast forward again to around 400 BCE to Athens, Greece. The ancient Athenians developed the court system that morphed into what we see today. During this time, aristocratic families ran Greece, and their representatives were called archons, and they had all the power, basically. The gap between the elite and the lower classes became so bad that the poor often had to sell themselves into slavery just to survive. Things in Athens were bleak if you were poor, and as the poor began to become restless, the elite became frightened, so they decided to elect a new archon to fix the situation. Solon, who became the lawmaker. The population of Athens swore an oath to abide by Solon's laws for 10 years, and only he had the power to make and change laws. He abolished all debts and completely reconstructed the political power system, linking power and wealth to merit as opposed to family lineage. Solon's rule lasted several years before power struggles began, and eventually power was given to 10 tribes and a new ruling body, the Boule, or Council of 500. Positions were elected by rich and poor alike, and we'll return to the Athenian system when we cover courts later this semester. Prohibitions against murder, theft, and perjury were found in the modern United States were preceded by similar laws over 3,000 years ago. However, these formal ancient legal codes were abandoned during the Dark Ages, when early German and Anglo-Saxon societies developed systems featuring monetary compensation for criminal violations. Before the Norman conquest in 1055, laws were pretty much the same as customs. It seems that the law was starting from scratch, like the tribal societies in 3000 BCE. There were tribes as before, and therefore there were wars. There were 8 large feudal holdings run by lords who required justice, usually in the form of settlements decided upon by the court. Guilt was determined by various methods. One was compurgation, in which the accused person swore an oath of innocence with the backing of oath helpers who would attest to the character of the accused. The number of oath helpers depended on the crime and the social status of the offender. The second way guilt was determined was trial by ordeal. This was particularly hairy. The accused would have to put his or her hand in boiling water to pick up a stone at the bottom of the pot, and if the wound healed in 3 days, it was considered divine intervention and the person was innocent. So remember, due to the lack of sanitation, most wounds would get infected and fester. So this wasn't a particularly good way of determining guilt or innocence, at least from the point of view of the accused. Other punishments included trial by combat. This is where the accused could challenge his accuser to a duel. This one was favorable among wealthy noblewomen who would choose a knight to fight for their honor. Obviously, whoever won determined the guilt or innocence. Additional punishments included public flogging, branding, beheading, and burning. This made obeying the law a particularly good idea. After the Norman conquest of England, William I declared himself king, and all land and land-based rights, including the administration of justice, were now the king's. Those nobles who supported him in war were given Anglo-Saxon land. He appointed royal judges who traveled throughout the land, holding court in each shire or county several times a year. This institution was called an eyre, E-Y-R-E, When court was in session, citizens under oath would tell of the crimes and serious breaches of the peace that had occurred since the last court. Judges then decided what should be done. If property was to be forfeited, the judge were to see that the king got his fair share. There were also local courts that settled many disputes, but the Norman settlers preferred to take their issue to the king's court. The present English system began under Henry II, when royal judges began to publish their decisions in local cases. These written decisions were then used as a basis for other decisions. If the new rule was successfully applied to a number of different cases, it would become a precedent, which could then be used in all future cases. This was the basis for what is now called common law. Crimes such as murder, burglary, arson, and rape were common law crimes whose elements were initially defined by judges. They were referred to as mala in se laws, or inherently evil and depraved. Sometimes the English Parliament enacted legislation to supplement the judges' decisions. These laws were called mala prohibitum. These are on the quiz, by the way. English laws kept changing to reflect existing social conditions. Just as the definition of crime is determined by an interaction between government and society, so are laws. The famous example of change is the Carrier's Law in 1473. The court decided that if a merchant hired a carrier to transport his goods, and the carrier kept the goods for his own purpose, the carrier was guilty of larceny. Previously, it was not a crime under common law when people kept something that was voluntarily placed in their possession, even if the rightful owner had only given them temporary custody of the merchandise. This system of Norman law worked well until a group of powerful noblemen rebelled against the heavy taxes and made King John sign the Magna Carta, which limited the king's power and authority. This is the basis of due process.